Great. Well, it's good to be with you all this afternoon. My name is Bradley Pierce. The most important thing about me is that I'm a Christian, saved by the grace of God, and that's why I do what I do, and that's why God has given me strength, and every one of us here. So we're grateful to Him for that. I'm also a husband. My wife Cindy is here, back there in the green. If you want to wave at her. And our youngest 5-month-old little boy Caleb is back there as well. But we have 9 more at home that we left with the grandparents, 5 boys and 5 girls. So we're very, very blessed. So we are for life, right? So I have been practicing law for 15 years, and about 6 years ago helped to start an organization, the Abolish Abortion Texas. And then we also have another organization now called Foundation to Abolish Abortion. Abolish Abortion Texas, we operate in Texas. Foundation to Abolish Abortion, we help other states by drafting bills. For example, the bill that Senator Mike Moon, formerly Representative Mike Moon, has filed here in Texas. We drafted that original bill that he filed and has filed since then. And we're grateful that we've been able to be involved at some level, even here in Missouri, through the Foundation to Abolish Abortion. We submitted a brief to the U.S. Supreme Court in the Dobbs case. We were among the 81 groups that submitted on the anti-abortion side. And by the grace of God, we just saw the end of Roe versus Wade, which was our very first argument in our brief, asking the court to overturn that. So we were very, very grateful for that. So let's talk about that. Where do we go from here? Roe is gone. What should we be doing? First of all, how should we be thinking about that, feeling about that? What action should we take based upon that? Should we celebrate? Should we mourn? And I think we should do both. And I think we need to be aware of what's going on. And most of all, we need to wake up and be taking action right now, because though we rejoice at the toppling of Roe, one thing we know for sure is that abortion has not been abolished in any state, much less every state, and the battle is very far from over. In fact, we may be much earlier in the battle than many people really realize. There's still so much more that needs to be done. So our first response to Roe being overturned, I believe, should be to celebrate. I think it is a good thing that Roe versus Wade has been overturned, and that nearly 50 years of judicial tyranny is over, at least in that one particular area. I don't know about you, but I was surprised that they overturned Roe versus Wade. In fact, even most of the pro-life organizations and attorneys that I've talked to, they were all hoping for it. Many of them were kind of naming and claiming it and kind of even boasting that it's definitely going to happen. But I think even many of them were still surprised when it actually happened. So it was a very pleasant surprise that I was very grateful for. They've had such a history since 1973 of every opportunity they get of reaffirming Roe versus Wade and doubling down on Roe versus Wade, that it's still shocking that they finally admitted that they were wrong in Roe versus Wade. So we're grateful for that. Again, if there's one thing we've learned with all of this, it is truly that the king's heart is in the hands of the Lord. He turns it wherever he will. We actually submitted a brief to the U.S. Supreme Court. It was supported by 21 organizations and 20 state legislators who also signed on to the brief. In fact, I'm looking at who signed on. And so from people all across the country, including Senator Mike Moon, signed on to our brief to the U.S. Supreme Court as well. Our brief, we said to the Supreme Court, and I quote from the summary, we call upon the court to fulfill its God-given and oath-bound constitutional duty to administer justice. We also call upon the court to restrain its unconstitutional abuse of power in Roe versus Wade in order to restore public respect for the Constitution, for the court as an institution, for the court's rulings in general, and for the value of human life itself. Additionally, we respectfully advise the court that for so long as the court does not overrule Roe itself, more and more Americans who are faithful to the Constitution can, should, and will be seeking to pursue the abolition of abortion via other peaceful constitutional means. Finally, we urge the court to recognize that a preborn person is entitled to the equal protection of the laws under the 14th Amendment. State laws protecting born persons should equally protect those not yet born. That was the summary. And then, like I said, Section 1 was really about overturning Roe, and it ended with, ultimately, the court's egregious decision in Roe is an affront to God and a malignancy that must be excised. It finds no basis in the text of the Constitution. Indeed, its holdings run completely contrary to the text of the Constitution, flouting both its text and spirit. As a result, the Roe decision and the court's repeated refusal to overrule it has undermined public respect for the Constitution, for the court as an institution, for the court's rulings in general, and for the value of human life itself, which God commands magistrates to protect by administering justice. Furthermore, the disregard for the rule of law demonstrated in Roe has metastasized into other areas. Ultimately, if the court does not amputate Roe from its body of jurisprudence, it will further fester and rot the foundations of our republic and its institutions, and it will further invite the righteous judgment of God. Amen. End quote. So thankfully, the court has amputated Roe versus Wade from its body of jurisprudence, and so we do celebrate that. We are grateful for that. But our enthusiasm is not without moderation. And we must temper our enthusiasm and our celebration there, because we must also mourn. My initial reaction, actually even before celebrating, as I that morning heard that the Supreme Court had overturned Roe, as I know we all were reacting to it, my initial reaction was I just said to God, God forgive us. God forgive us for what we have done and what we have allowed for nearly 50 years in this country. At the same time, I was joyful that they overturned Roe and grateful that they did so. But I was also mourning because there's over 63 million, those are just the ones who have been reported, over 63 million children have been slain under the auspices of Roe versus Wade and with the permission of the government of the United States of America and with the allowance of every state in the Union. I mourn for that, and I mourn because although many of us have been trying for years, and even here in Missouri, states never stood up to Roe versus Wade. There was never any state that stood up and said, no, this is wrong, this is evil, it's unconstitutional, it's unbiblical. It tells us to do what God forbids. It forbids us from doing what God commands. We must obey God rather than men. We're not going to follow Roe. We're going to ignore Roe, as we would put it. And no state ever did that, and that's to our shame that we didn't. And so I mourn that. No state had the courage to stand up to Roe and choose to honor God and follow the Constitution. No state has passed a bill of abolition to provide constitutional protection, equal protection for preborn babies. For all these years, the state simply submitted to the unconstitutional Roe decision and treated abortion like health care instead of abolishing it as murder. Because of that, more than 63 million lives have been lost, and that number continues to grow to this day. Because not surprisingly, much of America has internalized Roe and all the pro-life laws that we wrote that legitimized Roe and complied with Roe. The American culture has internalized that and now believes that abortion is health care and not murder. That's where most Americans are. So we also mourn for that. We also mourn what happened on that day because the Supreme Court fell short. Although they overturned Roe, they fell short of their God-given and constitutional duty in that case. And we also mourn because Roe versus Wade, at least based on my observation, it was not overturned because of national repentance and God somehow blessing us by its overturning. Thankfully, we are seeing some repentance in this country. And maybe God, even for just 10 righteous, chose to bless us and show mercy upon us by allowing Roe to be overturned. We don't know why He's allowed it. We're grateful that He has, though. But we haven't seen widespread national repentance. We see as our country just further corruption and further just decline into depravity in our country. So it wasn't the result of some national repentance. So we should celebrate, we should mourn. We also need to be aware about what actually happened in their decision and what could happen even now. First of all, even the Dobbs decision itself is at risk. The Dobbs decision that overturned Roe versus Wade, it was technically a 6-3 decision, but it was actually a 5-4 decision. So there were 6 justices that voted in favor of the judgment, so to speak, because the case was based on the Mississippi 15-week ban. It was whether or not to uphold the Mississippi 15-week ban. 6 justices said, yes, we should uphold the 15-week ban. Only 5 justices said, and we should also overturn Roe versus Wade. One of them, Chief Justice John Roberts, he said, no, we shouldn't overturn Roe versus Wade. We should just do something, that still upholds a woman's right to an abortion, that kind of moves the line, from viability to 15 weeks, just to allow for this. So Chief Justice John Roberts, he, was in favor of upholding the 15-week ban, but he voted against, or he was against. He filed a concurring opinion expressing that he was against overturning Roe. So it's really only a 5-4 decision to overturn Roe versus Wade, which means that if you flip one justice, you could get Roe versus Wade Part 2 all over again. So that could happen. If that happens, what will states do then? What will states do? Will we then muster the courage to oppose an unconstitutional and evil decree like we should have done with Roe? Will that be our moment of courage? Maybe. I don't know. Hopefully we don't have to face that. But there's other dangers that still face us. There's a bill, H.R. 3755, that's House Resolution 3755 in the U.S. Congress, that some people say would codify Roe, but it actually goes way further. It would not only establish a woman's so-called right to an abortion under law, but unlike Roe allowed for restrictions and regulations of abortion, at least after a certain point, whereas H.R. 3755 would actually eliminate every pro-life regulation and pro-life law in the country, or at least it would purport to do so. And based upon the last 49 years, the states would probably comply. That certainly has been our track record. H.R. 3755 has already passed the U.S. House. The President has already indicated he would sign it. It's already gone in front of the U.S. Senate, but it was blocked by the filibuster rule, which requires 60 senators in order to get a bill to the House or to the floor of the Senate for a vote. If they did get it to the floor, though, even one Democrat senator indicated he would vote against it. And that's Senator Manchin from West Virginia. He's indicated he would vote against that. Now, which sounds good. Unfortunately, he said, I would vote to codify Roe. He said he would vote to codify Roe. This one went too far, and it wasn't just status quo, it was eliminating every pro-life regulation. But he said, I would vote to codify Roe versus Wade, which means that if a bill could get to the floor, the votes are there to codify Roe versus Wade by the U.S. Congress, and it would be a tie vote with the vice president casting the tie-breaking vote, obviously in support of codifying Roe versus Wade. So the only thing that really stands between U.S. Congress codifying Roe versus Wade or not is the filibuster, which, although it requires 60 votes to overcome the filibuster, it only requires majority, 51, in the Senate in order to get rid of the filibuster. The filibuster rule could be completely eliminated, or at least eliminated for this particular area with only 51 votes, or 50 plus the vice president. So the possibility of Roe versus Wade being codified, by the federal government, just a different branch, is very real. It's a very real possibility. Now, again, Senator Manchin has said he would not vote to override the filibuster. but he's one man. And who knows what could happen. The president has already come out and now called for the Senate to do away with the filibuster. And so they could do that. Just last week, President Biden began calling for ending the filibuster so that the Senate could codify Roe versus Wade. And the Dobbs decision that overturned Roe versus Wade would not prohibit that. It would not prohibit Congress from codifying Roe versus Wade. As the Dobbs decision itself said, essentially we are returning this to the people's representatives. That means not only state representatives, but also federal congressmen and senators. So Dobbs even allows for, or at least doesn't prohibit, Congress from codifying Roe versus Wade. So both the court flipping one vote to reissue Roe versus Wade, or the Senate flipping one vote in order to codify Roe are both very real possibilities, and there's only, again, one person standing between in both cases. So the court did take a big step in the right direction by overturning Roe that we're grateful for, but they neglected their constitutional duty to hold states to the constitutional requirement to provide equal protection. That means that in a future case, we plan to go back to the court, as we did before, and urge them again to do just that. One of our arguments in our brief was not just that they should overturn Roe, but also that they should require states to provide equal protection. So the 14th Amendment to the Constitution says that no state shall deny to any person within its jurisdiction the equal protection of the laws. So the Supreme Court could say that there's no constitutional ability for them to say states can't outlaw abortion, but there is a constitutional mandate for them to say that the states must outlaw abortion under the 14th Amendment. So what is equal protection? Well, I'm going to talk about it a little bit more in the next talk after the break. But briefly, it just means that the same laws that protect you and me should protect babies who are not yet born. If we really believe that they're persons, then we don't need new laws. We already have laws that protect our lives from homicide in every single state. So we don't need new laws. All we need to do is take away the abortion exceptions to allow those same laws to protect preborn persons the same way they already protect born persons. That's all equal protection is. Unfortunately, one reason that the court didn't provide equal protection, even though we were asking for it in our brief, and there were 4 others who were also, out of the 81, there were 5 of us who asked for equal protection. But the party to the case, Mississippi, they did not. They did not ask for equal protection. In fact, they only somewhat asked for the court to overturn Roe. But we did in our brief. Our brief said, in addition to overruling Roe, the court should recognize that the Equal Protection Clause of the 14th Amendment requires that state laws protecting born persons against homicide may not deny equal protection to persons not yet born. Like I said, out of the 81 briefs on the anti-abortion side, only ours and 4 others made this argument. And Justice Kavanaugh, he voted to overturn Roe versus Wade, but he wrote a separate concurring opinion to actually address us and the other 4 who were arguing that the court should provide equal protection. And he was addressing some other things, but a big part of it was to address our argument. And Justice Kavanaugh's concurrence says, quote, "Some amicus briefs argue that the court today should not only overrule Roe and return to a position of judicial neutrality on abortion, but should go further and hold that the Constitution outlaws abortion throughout the United States." That's what we were arguing. No justice of this court has ever advanced that position. I respect those who advocate for that position, just as I respect those who argue that this court should hold that the Constitution legalizes pre-viability abortion throughout the United States. It's like, oh, that's nice. You respect me as much as the pro-abortion attorneys, okay? But both positions are wrong as a constitutional matter, in my view. The Constitution neither outlaws abortion nor legalizes abortion. To be clear, then, the court's decision today does not outlaw abortion throughout the United States. The Constitution does not take sides on the issue of abortion. On the question of abortion, the Constitution is therefore not pro-life nor pro-choice. The Constitution is neutral and leaves the issue for the people and their elected representatives to resolve through the democratic process in the states or Congress, like the numerous other difficult decisions of American social and economic policy that the Constitution does not address. Because the Constitution is neutral on the issue of abortion, this court also must be scrupulously neutral. That's what Justice Kavanaugh said. It's interesting that he doesn't even engage the actual arguments about equal protection, because ultimately, if a preborn child is a person, they're entitled to equal protection. The only question is, what does equal protection mean? But he doesn't even get into any of that. He just says, no one supports that. None of the justices of this court have ever advanced that position. Okay. Does that mean it's wrong, though? He doesn't really deal with that. So Dobbs does not provide equal protection, and as Kavanaugh says, it explicitly maintains a position of neutrality on abortion, just kind of punts it to the people's representatives, both at the state and the congressional level. So for 49 years, as the court, in its words, it says it arrogated authority to itself. That means it basically seized authority that did not belong to it. So the court arrogated to itself authority that did not belong to it. But now, today, as my friend J.R. Haas says, the court has abandoned its authority, abandoned the authority that does belong to it. So at first it was abusing its authority or grabbing authority that didn't belong to it. Now it's abandoning and abdicating the authority that it does have. So it's better, but it's still not what it should be. The 10th Amendment says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. And some people say, well, yeah, doesn't that mean then what Kavanaugh said, Justice Kavanaugh said, that the federal government really is neutral on the issue of abortion? It should be, left to the states. Well, that would have been true up until 1868, when we passed the 14th Amendment in this country after the abolition of slavery. The 14th Amendment says, in Section 1, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deprive any person of life, liberty, or property without the due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So did you hear that last part? No state shall deny to any person within its jurisdiction the equal protection of the laws. Now, many scholars, legal scholars, argue, well, how far does that go? What does equal protection of the laws mean? Does that mean every single law has to apply to everyone perfectly equally? And there's some disagreement there. But almost every scholar agrees that talking about equal protection that the 14th Amendment is at the very least talking about equal protection of existing laws which protect, as it said earlier, life, liberty, and property. So it is at the very least requires equal protection of existing laws that protect life, liberty, and property. Well, guess what? In 1868 and still today, there are laws on the books that protect life. There are laws against, on the criminal side, homicide. And today there are laws on the books on the civil side called wrongful death statutes, where you can sue for the wrongful death or the homicide of someone. So, with the understanding that equal protection of the laws includes laws protecting life, and the homicide laws already exist in every state to protect life, the only main remaining question is a fetus a person under the 14th Amendment? And our brief and the 4 other briefs, who argued for equal protection said yes, and I think it's undeniable that yes. Both the term person includes preborn persons, and that the drafters knew that and explicitly did not exclude preborn persons from the protection of the 14th Amendment. At the very beginning of the 14th Amendment, remember it says all persons born or naturalized in the United States. Right? They know how to say, hey, this applies to born people. You notice they didn't say, here it says all persons born. It doesn't say nor deny to any persons born or deny to any born persons at the end. It says any person. born or unborn, I would say. So, unfortunately, the Supreme Court did not reach that. They did not go so far as we were asking them to go. And in many ways, when we, the states, gave them that authority under the 14th Amendment, and then now they have refused to exercise that authority to defend innocent life, which now can still be slain in every state. And in some states can still be slain up until birth, or in every state can be slain up until birth by the mother, but in many states can be slain up until birth even by abortion doctors. It's a lot like them failing to exercise their authority to stop that is a lot like Pilate in the Bible. You remember Pilate? They brought Jesus to Pilate, and they said, we want to crucify him, right? And they said, we don't have the authority to put anyone to death. Only you do, Pilate. Right? So Pilate had the authority to put Jesus to death, but he also had the authority to stop the putting of Jesus to death. In fact, Pilate told Jesus that. He's like, hey, you know I've got authority over you. And Jesus said, you would not have any authority unless it had been given to you by our Father above. But Pilate had the authority to stop the murder of an innocent man, God-man, Jesus Christ. He had that power. But what did he instead do? He went out and washed his hands, and he said, this is on you. And the Jews said, yes, let it be on us and on our children. But does that mean that Pilate was innocent? No, he had the authority given to him by God to stop the murder of Jesus. But he chose to say, hey, this is on you. The Supreme Court has the authority under the 14th Amendment given to it by God through the people, through the states, to require states to provide equal protection of the laws to every preborn child. But the Supreme Court said, no, we're not going to exercise that authority. That's on you, people's representatives, states, Congress. We're punting that to you. And Justice Kavanaugh washes his hands the hardest, most trying to wash that off of his hands without actually even dealing with the arguments. So we need to be aware of all this, of what really happened and what really didn't happen in the Dobbs case. But we also need to wake up, and we need to take action as a church, as the church, and continue to fight for the true abolition of abortion. This is not the time to rest. It's not the time to rest on our laurels and say, hey, and that's what many people will do. They'll say, hey, we won, it's over, we're done. Go home, pack it up. We must not do that. If anything, this should just inspire us to greater action and greater efforts than ever. Because now there is a big barrier that's out of the way, and we praise God for that. The fight has just gotten easier in some ways, and in other ways it's just gotten harder. This is a big victory. In football terms, you could say we just got a first down, but the game's not over. Even though there's many people like leaving the bleachers, all right, it's over, celebrate. Right? They're headed to their cars. But we're just on our own 20-yard line. We still have a long ways to go. Our current situation after the overturn of Roe v. Wade is similar to the point where British abolitionist William Wilberforce was before he first started introducing legislation to fight the slave trade in 1789. Because at that time, slavery wasn't legal on the British Isles, but it was in its colonies, and the slave trade flourished throughout the British Empire. And Wilberforce didn't successfully accomplish the abolition of the slave trade until 1807, and the institution of slavery itself wasn't abolished until 1833. But his legislation was introduced and defeated many times before victory came. Similarly, today, while assisted abortions may now be illegal in some parts of our country, just like it was illegal in some parts of the British Empire, Wilberforce's day, it is not illegal in other parts. of the country. To bring things even closer to home, we could say that the 21st century abortion abolitionists are at a similar point in our work of abolition, similar point to the abolitionists of slavery in America prior to the Civil War. In antebellum America, each state made its own laws regarding slavery. Right? The Supreme Court didn't say you have to have slavery. Right? Every state had the power, had the authority. The Supreme Court wasn't stopping them. They could outlaw slavery. They could do that. Well, that's where we are today. Now, there are no federal rulings, statutes, or decrees to interfere with states regulating or abolishing slavery. As there was then and today, there is no federal ruling, statute, or decrees to interfere with states regulating or abolishing abortion. Each state, prior to the Civil War, did what was right in its own eyes. And that's what now the Dobbs case has essentially said. States, you do whatever is right in your own eyes. So if we're comparing it to the abolition of the slave trade or abolition of slavery in America, we haven't done it. There is no Emancipation Proclamation. There is no 13th Amendment. We haven't abolished it. Every state just does what is right in its own eyes, just like pre-Civil War America. After the reversal of Roe, the federal government may have stepped back from interference for now, but abortion still isn't abolished in every state. In fact, it's not abolished in any state. At least before the Civil War, slavery really had been abolished in some states. Some states really had abolished slavery. It really was totally illegal to own slaves in Wisconsin and Massachusetts and New York. It really was illegal for everyone. But even today, after Roe being overturned, it's not. It's not illegal for everyone to abort their children. It's only illegal for doctors to assist or nurses to assist with the abortion of children. So we're glad the court is no longer telling us we may not outlaw abortion, but we must realize that our fight for abolition is far from over. We are probably closer to the beginning of this battle than we are to the end. I would say definitely. Again, just because we got a first down, it would be foolish to act like we've won the whole game. If you do that, everyone's going to think it's over, and they're going to walk off the field, and a lot of people already are. The overturn of Roe is really just the end of the beginning of the fight to abolish abortion. And I don't say this to discourage those of you who may be new to abolition or to diminish the work of those who have already gone before and been in this fight for decades. I say it because the work laying in front of us is still a long way from over, and it's not time to leave the field. So what's left to be done? I thought you'd never ask. The laws of every single state still allow mothers to abort their own children, as we're going to be talking about a little bit more in our next talk. Pre-Roe laws and trigger laws may outlaw abortion clinics, but they do not outlaw abortion. So you may no longer have a clinic to go to minister to mothers getting an abortion, or to go and to stand out there and pray, but it's still going to be happening. Because mothers can perform do-it-yourself abortions up until the moment of birth in every state, and there's no state laws that prohibit that. Most easily, they can take abortion pills. These can be mailed in from states that allow abortion. So California can mail pills to Missouri or to Texas or to any other state that has either a pre-Roe law on the books or a trigger bill that's gone or going into effect. They can be mailed from other states, or they can be mailed from internationally. There are abortion pills being mailed from India to people. Now, there's a federal law that prohibits this, you may not be aware of. There's a federal law, it's commonly known as the Comstock Law. You can find it if you want to look it up at 18 USC, that's United States Code, 18 USC 1461. That's 18 USC 1461. Let me read it to you. It says, every article or thing designed, adapted, or intended for producing abortion or for any indecent or immoral use And every article, instrument, substance, drug, medicine, or thing which is advertised or described in a manner calculated to lead another to use or apply it for producing abortion, or for any indecent or immoral purpose. And every written or printed card, letter, circular, book, pamphlet, advertisement, or notice of any kind giving information, directly or indirectly, where or how, or from whom, or by what means any of such mentioned matters, articles, or things may be obtained, or made, or where or by whom any act or operation of any kind for the procuring or producing of abortion will be done or performed, or how or by what means abortion may be produced, whether sealed or unsealed, I'm going to skip ahead, is declared to be non-mailable matter and shall not be conveyed in the mails or delivered from any post office or by any letter carrier. So that's federal law, and that's still in the books today. It's written pretty well, pretty comprehensive. Guess what the Biden administration, they've actually replied to this already. Guess what they've said they're going to do? They're going to ignore it. They're going to ignore this law. Isn't that interesting how people on the pro-abortion side will just ignore federal laws? They believe pretty strongly in their side. They've even put up a website encouraging this. The Biden administration, you can go to reproductiverights.gov. That's reproductiverights.gov. And you can read there, quote, "Your right to access abortion services. Following the Supreme Court's decision to overturn Roe v. Wade, access to abortion will depend on the state you live in even more than before. Medication abortion has been approved by the FDA since 2000 as a safe and effective option. Federal regulation permits medication abortion to be dispensed by telehealth and sent by mail via certified prescribers and pharmacies, in addition to in-person dispensing in clinics, medical offices, and hospitals." So they're encouraging women to order abortion pills, and they're telling them it's totally legal to do this. Abortion may be illegal in your state, but it's not illegal for you to order abortion pills and do a telehealth visit with someone in California or India, and for them to just mail the stuff directly to you. And that's what's going on right now. That is being explicitly encouraged by the Biden administration. And that can be done at least up until 12 weeks gestation. And there is no law in any state prohibiting mothers from murdering their own preborn children using these pills or by any other method. What else do we still have after Dobbs? Well, mothers also we have abortion tourism, is what it's being described as, where mothers can go to other states and get an abortion there and then come back home. Or mothers can go to other countries and then come back home. And companies are even telling their employees that they'll pay for them to abort their children, which seems incredibly, not just evil, but incredibly self-serving. You know, companies telling their employees, hey, kill your baby and get back to work. It's probably going to cost them way less for the mother to just kill her baby than it would for them to give her maternity leave. This is why, like the abolition of slavery, abortion must be made illegal in every state across the country and across the world, and why our battle to do that is just really beginning. Abortion needs to be abolished in all 50 states for the glory of our God and for the love of our littlest neighbors. Even with Roe out of the way, it won't be an easy fight, although it has gotten, at least in one sense, easier, which we're grateful for. We need to be urging the Supreme Court to take the next step and hold that states must provide equal protection. We need to be urging Congress to exercise its power under the 14th Amendment to enforce the Equal Protection Clause and require states honor it, right? Congress doesn't have the power, we believe, to prohibit states from abolishing abortion, but they do, under the 14th Amendment, have the power to force states to abolish abortion. We need to be urging the next presidential administration to enforce existing laws prohibiting mailing abortion poisons and everything else. We need to be passing bills in every state, which is what we're here to talk about more than anything else, We need to be passing bills in every state that remove abortion exceptions from state homicide codes so that persons before birth are protected equally by the same state laws protecting persons after birth. That's called equal protection. And I'll explain more about what that looks like here in my next talk. But now is not the time to be hanging up our armor, to be laying down our sword, to be going to sleep. Now is the time to enter the battlefield. If you're not already in it, now is the time to get in it. Now is the time to dig in and press in. Now is the time to banish fear. Right? You're afraid of the Supreme Court? No more. There's one less enemy in your way now. Get in the battle. Now is the time to crush any apathy that you still have and crush it every day. Now is the time to put aside worldly wisdom and pragmatic half measures and wholeheartedly trust God and do His will, His way, and trust Him with the results, and to do it on our knees in repentance before Him, begging for His mercy. And if it was Roe standing in your way before, that hurdle's been demolished, and now it lies in the rubble, and we dance on it. We're grateful for that. But what is your excuse for standing idle now, if you are? Now is the time to joyfully join in the ranks of abolitionists across the country to fight for equal protection for every preborn baby from the moment of fertilization and to settle for nothing less than that. Isn't that what you would want for your own life? Isn't that what you would want for your own children? That's how we love our neighbor as ourself. Exactly. It's by fighting for that. It's time to keep fighting and fight to the finish. Are you ready to gird up your armor and keep fighting? I hope you are. Because it needs to be no surrender, no compromises, no retreat, no baby left behind until abortion has been completely abolished to the glory of God. Thank you.
Hey guys, thank you for watching. To see more content related to abolishing abortion, please like and follow this channel. To stay informed or find out how you can support the work to abolish abortion in Texas, visit our website at abolishabortiontx.org. With your support, we will continue to create content to bring greater awareness to this modern-day genocide and work to mobilize Christians to do something about it. We appreciate your support and help in sharing this content with your community of friends and family. Thank you, and God bless.